Today we're here for Uche. For those of you who don't know, Uche was born in Lagos, in Nigeria. She got her first degree, a Bachelor of Arts in Nigeria. She left there at the age of 20. She went to London, where she got her law degree. She then went across the Channel, went to Paris and got an MBA from Paris. She then went and worked in New York as a trader on Wall Street, and then she got an LLM from the University of Sydney. The whole time doing this, well, she's well, not the whole time, but she's a mother of three, of course, so it's a massive achievement. So congratulations to Uche, and of course we love having her on our floor. She's done a fantastic paper on the law surrounding cyber warfare. It's such an interesting area of law because throughout history there have always been important bright lines drawn as to when people should, I'm talking normatively, should and shouldn't commence warfare. But those bright lines have always had to change as warfare has modernised. And now we've reached the point where we're dealing with cyber issues. So questions of, for example, state sovereignty have a big question mark next to them because when data and domain is stored in something called a cloud, then the idea that all of that is interconnected doesn't necessarily sit well with what traditional concepts of sovereignty have been. And as Uche will identify, the main theme running through her paper is that in this area particularly, it's not so much the law that is driving reform, but rather it's strategy that's driving the change in law. And just as an aside, before I get Uche up here, I'm sitting here looking at a paper that Uche's put on the lectern, Cyber Attacks and Use of Force, Back to the Future, Article 2.4, by a chap called Matthew C. Waxman. I think he's a fair few footnotes throughout Uche's paper by Matthew C. Waxman. Matthew Waxman, he'd only, if he's 40, he'd only be in his early 40s. He went to Yale. He clerked for David Souter, a former associate judge on the Supreme Court of the US. He's now a professor at Columbia. He was one of my professors there. He took a number of courses. He took a course in national security law. On the first day of the course, he turned up and just to demonstrate his credentials, he probably felt that he needed to do that because he looked so young and wet behind the ears. He had a picture of himself sitting in the Situation Room of the White House on 9/11, sitting with Rumsfeld and George W. Bush. So he was right in the centre of the whole thing, and he knew his stuff. He was a very clever guy, and he's obviously written extensively on the issue of cyber warfare. And just in passing, Uche, when she was working as a Wall Street trader, happened to be in New York City, downtown, on that fateful day as well. And with that, I'll pass over to Uche.
Hi, good evening, everyone. I've always had an interest in IT. Prior to coming to the bar, I was corporate counsel in a number of IT companies, US multinationals. So when Tom asked me if I wanted to do a CPD, I just basically said I was happy to do it, provided I was given an opportunity to write on an area of interest. And Tom also said to me to assume that everyone has read the paper, so he advised not to go through the paper. And so my discussion will revolve around the ideas articulated in the paper. And the assumption is that there has been a cyber attack and Australia's critical infrastructures have been attacked. And Secondly, then I'll go through a very popular case called Stuxnet. So this is what's considered to be the first major state-sponsored cyber attack that involved Iran, the US, and Israel. So the paper, in a sense, just examines the laws and norms that govern, or that will govern and regulate Australia's response to a state-sponsored cyber attack. And I use the word will because it's quite speculative actually, because we have never really experienced any hostile cyber activity that has been instigated by a state or even a non-state actor for that matter. So no one has had so much interest in us as to want to disrupt our systems or destabilize our financial institutions per se. However, the Australian Cybersecurity Centre does predict that in the event of any future attack, our critical infrastructures, our military capabilities, and our government networks may be targeted. And on that note, I'll just try to, I'll go to talk about that case that I mentioned, and it's called Stuxnet. So in 2010, facilities in Iran's nuclear enrichment facilities in somewhere called Natanz were secretly brought down by a computer code. That computer code was not recognized. It was considered to be the first act of cyber war that was instigated by one country against another. And some, sorry. I thought I put it. Maybe there's a cyber attack. Sorry about that.
We can edit that out.
So some commentators did call the virus the atomic bomb of cyber warfare. No country admitted responsibility, but experts from the US multinational company Symantec did suggest that Israel was involved. And the former NSA contractor, the popular Edward Snowden, had at some point in time indicated that the US, along with Israel, did create that malware. Till then, no one knows how that was developed, but it's widely considered that it must have been sponsored by a state. It couldn't have been hackers or non-state actors. So to give a bit of background and timeline with respect to that incident. So around 2002, this is when George Bush gave the famous Axis of Evil, made the Axis of Evil comment. And then this was around January 2002. And then going forward, around August 2002, an Iranian dissident group disclosed that the government was enriching uranium at that facility. And then in 2003, Iran openly acknowledged that that facility did exist. And around 2006, the international community launched diplomatic discussions to encourage Iran to stop the nuclear program. Sometime in 2010, the existence of that Stuxnet worm was made was disclosed publicly. And then somehow around September 2010, Iran did admit that its personal computers had been infected by the virus. And around November 2010, they actually stopped. The program was stopped without giving any reason. So the news was that the code infected the specified industrial control systems used by the Iranians without any signs of infiltration.
And after 13 days of infection, the virus turned itself on and was able to speed up or slow down the centrifuges, causing them to destroy themselves. The sabotage was so sophisticated, the Iranians didn't even know what was happening. There was no signs of problems. There was no signs of the monitoring systems that something was amiss. But it was after some time that the computer code escaped due to a programming error and spread throughout the internet and infected computers around the world. That was in Iran. The Iranian government discovered that it had been attacked. And when asked about the Stuxnet incident, the then CIA and NCA director said something to the effect, I don't know, and if I did, we wouldn't talk about it anyway. So this was a case, this is one case of a cyber attack with respect to a cyber attack that is sponsored by another state. And with that, I'll go to a speculative environment where we have basically assumed that Australia is under attack. Different states have different definitions of what constitutes the critical infrastructure. Australia does define critical infrastructure as those physical facilities, supply chains, information technologies, and communication networks which, if destroyed, degraded, or rendered unavailable for an extended period, would significantly impact on the social or economic well-being of the nation or affect Australia's ability to conduct national defense and ensure national security. So this basically includes all our communication networks, our computer systems, our banking institutions, our defense facilities, etc. I think one point I'd like you to think about in the course of this discussion is, given the definition of Australia's critical infrastructure, what would you think, irrespective of what the international law obligations are and the circumstances in which any rights that we may have or under those laws will be enlivened, to think about what you would consider, what you think Australia would do in the event of a conflict between our national interest and our international law obligations. And for that reason, on that basis, our discussion is going to revolve around 5 questions today. So the question that does arise or that comes to the fore is, what is a cyber attack? When is a cyber attack state-sponsored? And at what point does a cyber attack escalate to the point of becoming an act of war? And also, when is a cyber operation or any force that is exerted in cyberspace tantamount to the use of force? We'll also look at when does a cyber attack qualify as an armed attack? So in any of these scenarios, the fundamental question would always be, has a cyber attack occurred? There's an avalanche of cyber operations and activities in cyberspace. There are lots of cyber incidents that happen on a day-to-day basis involving non-state actors, hackers, private individuals, rogue societies, name it. However, not every cyber incident is a cyber attack. So there is a group, the United Nations International Group of Experts. They are basically a group of people, experts, who basically provide guidance on what the law is within this area. And they have a manual, and thanks Tom for buying this and making it available. So it provides guidance as to what the law is within this area. The Australian government does describe cyber attack as a deliberate act through cyberspace to manipulate, disrupt, deny, degrade, or destroy computer networks or the information resident on them with the effect of seriously compromising national security, stability, or economic prosperity. So when you look at that definition, it looks at the nature of the incident, how the incident affects the functionality of the target computer system or network, and the consequences of the incident. However, there is a second definition of cyber attack, and that's the definition that is adopted by this group of experts, and that's the definition that that is relevant for the purpose of construing what your rights or what our rights and obligations would be under international law. And that definition says that a cyber attack is a cyber operation which, whether offensive or defensive, that is reasonably expected to cause injury or death to persons or damage or destruction to objects. So when you look at that definition, it focuses solely on the effect or the outcome of the incident. And what's a bit surprising is that it is only a cyber attack if there is injury or death or damage to property. So it basically means that the definition requires an act of violence. So this implies that non-violent operations, irrespective of the effect on the victim's state, will not cut it. The definition also requires that the consequential damages be reasonably foreseeable. In my opinion, I think that threshold is rather high and very unrealistic, considering all the damages or the scale or gravity of consequences that could emerge from a non-violent cyber attack. And then that brings us to the question, when is a cyber attack state-sponsored? So in every cyber attack situation, the paramount question, which will basically drive the nature of the response, would also revolve around identification and attribution. The Australian government would want to know whether the attack is state-sponsored. It would also want to know the identity of the perpetrators. And so the first step would involve identifying the provenance of the cyber attack and the nature of the weapons that have been employed. Obviously, you would have very bright sparks, military and computer experts who will be able to register findings on the possible identity of the perpetrators. However, it's of paramount importance that the perpetrators be identified with a reasonable degree of certainty, bearing in mind the consequences that will flow if that exercise is not carried out accurately. I mean, you don't want to go attack China if you've been attacked by Indonesia. So now, identifying the perpetrators would always pose technical difficulties and challenges. So while the physical aspect of an attack will be obvious for forensic analysis per se, cyber attacks can be disguised by IP spoofing or by the use of botnets. And in most cases, cyber attacks are anonymous. And so even though the attacks might seem to originate from a particular location, it could actually not be the right location. It does not necessarily mean that the owners of the computers that were used or employed in the attack were actually responsible for the conduct in question. And that then leads us to the question of attribution. So a cyber attack is state-sponsored if it is authorized by a state and can be attributed to the relevant state. So in circumstances where, for example, you have non-state actors who have possibly acted under the guidance and control of the state in question, obviously that state will be rightly attributed to the conduct. So the law that governs that area is the International Law Commission Articles. So under Article 1 of that regime, the state will be directly responsible if it is ascertained that the state in question actually was responsible for the conduct. And if the conduct was by organs of the state, Article 4 basically attributes the conduct to that state. If the conduct was by persons or entities exercising
government authority, Article 5 attributes the conduct in question to the relevant state. And then on the Article 8 basically attributes conduct with respect to direct or control by the state in question. So that's the article that would enable third-party participants to be, the conduct of third parties to be attributed to the relevant state. But the question there is the degree of control which must be exercised by the state in order for the conduct to be attributable. So this was a question that was before the court, the International Court of Justice, in the Nicaragua versus US case, which is a very popular case with respect to control. The approach, the ICJ approach was a bit restrictive. The test that was posed was, so what has to be proven on that, the ICJ did adopt a restrictive test, and that test is what has to be proven is that the state had effective control of the military and paramilitary operation in the course in which the violations were committed. So the question that then arises is what exactly is effective control? And this was in circumstances where the US had basically financially sponsored the group. They had organized them, they had trained them, they had equipped them. So it was obvious that we were basically operating under the instruction of the US government. However, certain commentators have also said that having a restrictive approach or a restrictive test does also ensure that states are not conducts are not easily attributable to a state. There was a second case which did adopt a less restrictive case, and that's the case in the appeals chamber of the International Criminal Tribunal for the former Yugoslavia. That case says that the requirement of international law for the attribution to states of acts performed by private individuals is that the state exercises control over the individuals. The degree of control may, however, vary according to the factual circumstances of the case. So that's a less restrictive test. So in some cases, identification and attribution may actually prove insurmountable. And for example, in the widely reported case of government, that cyber attack took place in 2007. In that case, the cyber attack was in response to the moving of a Soviet war memorial, and hackers had interfered with the Estonian government website using distributed denial of service. It was apparent that the attacks came from Russia. Malicious traffic indicated political motivation. A lot of the language was in Russia, but there was not sufficient evidence to actually attribute the conduct in question to the Russian government. So that just basically brings to the fore the challenges that will be related to attribution. So even in a case where you identify the third-party perpetrators, the question is how do you know who sent them? Is there a system where you can ensure that you will be able to get the information for them in order to attribute it to the right state? And then, and also, the victim state is not likely to publicize the security breach in question. It's not exactly news that you're going to put on CNN that there has been a compromise in your national security facilities. And also, and this was a case in the Stuxnet case, Iran was very reticent about the incident. Iran never talked about the effects or whether or not it had knowledge of the source of that code in question. So what then happens is that without attribution, without attribution, there can be no deterrence, and also the laws that the response that we're trying to anticipate or speculate, because we're basically speculating what will we do if this happens. So if we never get to the point where
we can actually practicalize or put this in practice. Nobody would ever, this area of law would never eventuate. You would have no precedents to rely on. And then the next question is, when is a cyber attack an act of war? It's kind of it's also a speculative question, because there is nothing within the literature in this area which basically defines or tells you when a cyber attack will become an act of war. However, when we go through Article 51 and the circumstances in which the right to self-defense will be enlivened, what readily comes to the mind is that, and the paper basically argues that a cyber attack which triggers the self-defense right in Article 51 of the United Nations Charter will be deemed to be an act of war. The United Kingdom, under Secretary around 2010, did indicate that any cyber attack that took out a power station will be an act of war. President Obama, sometime around the same time, did indicate that any attacks on U.S. defense and military networks will be considered an act of war. And I would also choose to think that any attack, any state-sponsored attack that basically compromises what Australia has defined as its critical infrastructure will be deemed an act of war. So I'll quickly go to the international law framework. Basically, we'll be looking at Article 51 and Article 2, para 4. Sometime in April 2016, our then Prime Minister, in April 2016, our then Prime Minister, Malcolm Turnbull, did emphasize that, did basically publicly disclose that Australia had offensive cyber capability. That was the first time that such a disclosure had been made. But he did also state that the use of such a capability will be subject to stringent legal oversight, and whatever we do will be consistent with our international law obligations. So Article 2, para 4 basically says that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. So there are two prohibitions under that, under Article 2, para 4. So there's a prohibition against the use of threat, and also there's a prohibition against the use of force. There are also two exceptions to the prohibition on the use of force, and I'll call going forward, I'll refer to the prohibition on the use of force as the prohibition. So the two exceptions to the prohibition can be found in Article 51. So that's the provision that enables or that grants a right to self-defense if the necessary requirements are met. And so assuming we do pass the hurdle of identifying the perpetrators, and we have successfully attributed the conduct in question to a state, Indonesia or China, I'm not sure, but any state that is likely to attack us, would then have to assess whether any of the planned cyber operation, so we're basically thinking of how would we respond, and what are the legal constraints that will basically determine what we'll do and what we cannot do. So if we've crossed that threshold, we'll just have to ensure that whatever we do does not include the use of force as prohibited in Article 2, paragraph 4, unless the attack in question can be deemed to be an armed attack which enlivens the self-defense right in Article 51. So the International Court of Justice has basically says that those two provisions do apply to any use of force, regardless of the weapons employed. However, with respect to cyber operations, it's not the instrument used that determines whether the use of force, whether the use of force threshold has been crossed. Rather, it is the consequences of the operation. So it's more of the scale and the effect of the attack itself. And the definition, based on the Wiseman, the international group of experts, they say that a cyber operation constitutes a use of force when its scale and effects are comparable to non-cyber operations rising to the level of a use of force. It's important to also state that the fact that a cyber operation does not qualify as use of force does not necessarily render the act in question or conduct in question lawful. It may constitute a violation of a breach of the prohibition on intervention or some other articles within the Charter. And then that brings us to what then is an armed attack. So basically, if we do pass the threshold for an armed attack, the question of use of force does not arise per se, because it's an exception. And for the question then becomes what will be deemed to be an armed attack. Now, the law is still unclear precisely as to the precise point at which the effects of a cyber operation will tantamount to an armed attack. In the Nicaragua case, the ICJ did accept that a definition of armed attacks is not included in the Charter and is also not part of treaty law. But it did distinguish between an armed attack and a mere frontier incident. So cross-border incursions that are minor in their scale and effects will be considered to be mere frontier incidents rather than armed attacks. For armed attacks, there is a requirement that there is sufficient gravity to constitute a grave use of force. But this does not mean that a sovereign state has no remedy for low-level violations. Remedies are available for mere frontier incidents, which would include retortions and countermeasures under the Charter. There is a scholarly debate around the approach to use in determining when a cyber attack will become an armed attack. And for a state that is intending to retaliate or to commence any form of response, you want to be in a position where you can actually say that the attack in question has enlivened your right to self-defense under the Article 51, because subject to certain principles, the principle of necessity and proportionality, enlivening the right to self-defense basically means that you can use military force in your response. And under those debates, there's a group that says that an armed attack, so based on there are three approaches. One is called the instrument-based approach, the target-based approach, and the effects-based approach. So the instrument-based approach says that a cyber attack alone, on its own, will never constitute an armed attack for the purposes of Article 51 because it does not employ the use of military weapons. And so in that case, it will only be an armed attack if military weapons are used. So that approach basically leaves much to be desired, considering all the consequences that could flow from a cyber attack that doesn't employ the use of military weapons. And then the target-based approach says that a cyber attack is an armed attack based on the nature of the targets. So if, for example, like Obama says, if you touch our defense or military facilities, that's an act of war. That these groups say, based on the nature of the target or the nature of the target, that will determine whether the attack in question is armed attack. And then, of course, you have the effects base, and that's the position that the group of experts prefer. So that approach is based on the effects, the outcome of the cyber attack in question. I'll wrap up soon so we can go through the scenario and field I think I've covered ground with respect to all that relates to the laws that will apply with respect to the United Nations Charter. And what we see or what we know is that in the event of a state-sponsored attack, Australia's response could comprise of diplomatic, economic measures. However, the extent to which the only problem that I see with all of the definitions is the definition that has been adopted by the wise men, the governmental experts. The definition of cyber attack, I think, is very restrictive. I can't see how that's possible. I can't see that if, for example, we have issues, for example, if we wake up one day and our financial sectors, our computer networks within the financial services sector is infiltrated, the integrity of the data is compromised, our national security systems, everything is down. I don't see that we would not be able to act in self-defense because there is a definition that says it is not a cyber attack until somebody dies or until there's damage to objects or property. Otherwise, the answer to the question how we'll respond, like I said, is still very speculative. And because there are no opportunities to actually test out the law in this place, it remains a very gray area.